This judgment is given following a hearing in connection with an application for permission to appeal made by the parents of Archie Battersby, who is a 12-year-old boy who for some weeks now has been in a deep coma on a life support regime in hospital. Tragically, on the 7th of April 2022, Archie was found to be in a very profoundly damaging state by his mother with a ligature around his neck in their home. He was taken to hospital where he has been ever since. As I understand it, he has not regained consciousness since that time. To her enormous credit, his mother has effectively not left his side since that day. The family, as best they can, have visited regularly, as have many friends. He is a much-loved boy who is the centre of these proceedings and the centre of all this loving activity by his family, in particular his mother and his father. Initially, proceedings were commenced by the Barts National Health Trust, seeking declarations from the High Court. Those developed into an application before Mrs. Justice Arbuthnot, who, in a judgment on the 13th of May 2022, made orders providing for brainstem testing. She also directed a further MRI scan. At the final hearing before her in early June, the focus was upon whether or not the court could and would make a declaration as to whether Archie was, open quote, brain stem dead, close quote, thereby permitting the trust, if that declaration was made, to withdraw the life-sustaining treatment. On the 13th of June, that was the decision that Mrs. Justice Arbuthnot came to, and she made the declarations that were sought. On the 29th of June, the Court of Appeal, comprising the Master of the Rolls, I and Lady Justice King, allowed the appeal against that decision and directed that the matter should be returned to the High Court. Our judgment was handed down on the 6th of July. The case was allocated to Mr. Justice Hayden, who is the Vice President of the Court of Protection, as well as being a judge of the Family Division. On the 11th of July, a full-day hearing took place before that judge, and he handed down his judgment on the 15th of July. He concluded that it was not in Archie's best interests for the life-sustaining treatment to continue, and therefore declared that it would be lawful for it to be withdrawn. The parents, with alacrity, issued their application for permission to appeal, which was filed on the 18th of July. In determining issues of this nature, when they come before a court is required to afford paramount consideration to the best interests in the widest sense of the individual child. The judge must maintain a keen and unwavering focus upon the child's best interests throughout the hearing, and that this also must be the central core of any concluding judgment. The question of whether the judgment of Mr. Justice Hayden demonstrates that this was his approach is now at the centre of the parents' case on appeal. It is helpful at this stage to summarise the content of the judgment. At the start, the judge was clear that the investigation of where Archie's best interests now lie, quote, requires unswerving focus on Archie, unquote. In paragraphs 5 to 24, the judge gives a detailed account of Archie's current medical condition. At paragraph 25, he then said this, quote, determining where Archie's best interests lie is not solely a medical issue. It's important that I place him, his personality, his wishes, at the centre of this process. Respect for Archie as a person involves a clear recognition that, as a human being, he he is more than the raft of medical complexity that I have set out above. He is not, in my judgment, simply who he is now, but he is also who he has been throughout his short life." End of quote. Mr. Edward Devereux, Queen's Counsel, leading counsel for Archie's parents on appeal, described that paragraph as being the right direction for the judge to have given to himself at that stage. The judgment then continues from paragraphs 26 to 31 with the detailed account drawn from the written statements together with the oral evidence of both parents and Archie's children's guardian, in which the judge developed a detailed pen portrait of this previously lively and most engaging boy. Archie's religious beliefs are a prominent aspect of the case presented by the parents to this court, as was clearly the case before Mr. Justice Hayden, who summarised matters in this way at paragraph 30 of his judgment, and in the printed version, paragraph 30 will then appear. Another important factor for the judge to consider was Archie's view on the very question that was before the court. He summarised the evidence at paragraphs 31 and 32 in this way, and again paragraphs 31 and 32 will be reproduced. In considering Archie's best interests, the judge, and now this court, must engage in the full detail of this 12-year-old boy's medical condition. The judge summarised the evidence of Dr. F., a consultant paediatric intensivist. He considered that her evidence cast some light on, quote, "the reality of Archie's day-to-day experience," close quote. The summary is short but devastating in describing the all-embracing nature of the damage that has resulted from the original brain injury 3 months ago. Quote, "She told me that with brain injury as devastating as that sustained by Archie, the loss of brain function inevitably causes adverse cardiovascular, respiratory, endocrine, metabolic, and hematological change. This in turn creates instability in organ function and in the heart." In her statement, Dr. F. lists the treatments that seek to manage or mitigate this instability. The judge then went on at paragraph 18 to list no fewer than 17 interventions or other aspects of the treatment regime which are required to maintain the functioning of Archie at this very basic level, Archie's body at this very basic level. The description given is far, far more than that of a boy who is simply on a ventilator. For example, the ability of the brain to monitor, moderate and control bodily fluid and the discharge of urine has completely gone. Whilst, impressively, a drug, vasopressin, can be given to seek to do what the brain would normally do, this is, as the judge said, a second-rate understudy for the main actor, the brain itself. A further consequence of the brain's failure is that Archie's gut has also failed. Archie has lost a very significant amount of weight, and again medication has been given in an attempt to slow down the gut in order to facilitate better food absorption. But this is second best to what would otherwise have been moderated by brain activity. Archie has become anemic, with, in the words of the judge, the following consequences, quote, "Inevitably, anemia adds to the burdens that have been discussed above. It further increases the risk of infection, intestinal disorders, abnormal heart rhythm, and low blood pressure. Archie needs blood tests every hour or two to monitor the acids and salts in his blood. He requires intermittent transfusions." End of quote. Although this is contrary to his mother's experience of feeling Archie squeeze her hand on one occasion, none of the medical staff has witnessed any sign of spontaneous life in him during this extended period of intensive observation. The following account appears in the report of the children's guardian. G, an advanced nurse practitioner, told me that she has never witnessed a response from Archie to any procedure. There is no cough, no gag reflex. Even when uncomfortable or painful procedures are taking place, she said there is no response from Archie. G is aware that nurses on the unit are finding it difficult. They feel it, quote, "upsetting to look after someone who they know has an irreversible injury, and sadly every intervention feels futile," end of quote. "I was told that Archie looks like a completely different child from the one who was admitted in terms of his pallor, weight loss, and muscle tone. They all feel incredibly sad for this family." End of quote. Archie's condition and the awful predicament that he and his family are in have achieved widespread press and media publicity, much of which has included a photograph showing Archie as a most engaging boy. Tragically, the consequence of the catastrophic brain injury that he sustained on 7th April is that Archie is no longer the boy in the photograph. He is, as the detailed description given by Mr. Justice Hayden and confirmed in the short account of Nurse G demonstrate, someone whose every bodily function is now maintained by artificial means. Heading The Choice. Before turning to a brief description of the legal context, it is helpful to be clear that as to the choice of options that was placed before the judge. Given the parlous state of Archie's condition, the choice was necessarily bleak, and the difference between the options, whilst important, was narrow. The outcome sought by the hospital trust, supported by the children's guardian, which I will call option 1, was for life-sustaining treatment to be withdrawn from Archie at an arranged time at which family members might be present, and during which the process that would then follow would be supported by the presence of all the relevant medical personnel. Option 2, strongly favoured by Archie's parents and family, is for the current life-sustaining treatment regime to be continued until such time as Archie's body gives up and he would die, to use their word, naturally, and again, to use the family's phrase, at a time, quote, chosen by God, close quote. On 10 July 2022, in an open letter written to the solicitors for the other parties and to the judge's clerk, the solicitors then acting for the parents described the choice to be made in these terms, quote, "As all parties now accept, the central issue in this case is about the timing and the manner of Archie's death. Your client's medical evidence is clear that his life expectancy is now measured in weeks rather than months or years. Our clients, however, have a strong moral objection to the proposed act of removing Archie from the ventilator, in the knowledge that this will inevitably lead to his death. Our clients believe, based on their knowledge of Archie and what he had told his mother and his brother, that his own view would have been the same. On that basis, our clients strongly advocate that Archie's death should be as, quote, natural, unquote, as possible, and the exact timing of his death should be determined only by God." Then later, whilst they continue to hope and pray for a miracle, our clients acknowledge the medical evidence about the severity of Archie's condition and the clinician's view that he has no prospect of recovery. End of quote. In the course of his oral submissions to this court, Mr. Devereux confirmed that the letter represented the parents' position, both in terms of their acceptance of no prospect of recovery, and that Archie's death is most likely to occur within weeks, as opposed to a period of months or longer. But although the judge did not spell the choice out with the same degree of precision, it is clear that the choice between option 1, an arranged removal of life-sustaining treatment with the inevitability of death a short time later, and option 2, the continuation of life-sustaining treatment in the knowledge that in the very near future Archie's bodily functions would collapse in an unplanned manner, was before the court. Heading The Legal Context. No point of substantive law is raised in the grounds of appeal, and it is accepted that the judge gave himself an accurate self-direction as to the law. It's therefore necessary only to spend a short time summarising the approach, and it is to be found in the Supreme Court decision in the case of Aintree University Hospitals NHS Foundation Trust against James, 2013, UKSC 67. I'm only going to make one or two short quotations from this judgment. The first is to identify the test to be taken on appeal. In paragraph 42, giving the leading judgment of the Supreme Court, Baroness Hale of Richmond said this, quote, "But if the judge has correctly directed himself as to the law, as in my view this judge did, an appellate court can only interfere with his decision if satisfied that it was wrong. Then there's reference to Re B Care Proceedings 2013 1 Weekly Law Reports at 1911, before her ladyship continued, in a case as sensitive and difficult as this, whichever way the judge's decision goes, an appellate court should be very slow to conclude that he was wrong. End of quote. Earlier, at paragraph 35, Baroness Hale stressed the importance of the right to life. She said this, quote, "The authorities are all agreed that the starting point is a strong presumption that it is in a person's best interests to stay alive. As Sir Thomas Bingham, Master of the Rolls, said in the Court of Appeal in Bland's case, quote, a profound respect for the sanctity of human life is embedded in our law and our moral philosophy." End of quote. Nevertheless, they are also all agreed that this is not an absolute. There are cases where it will not be in a patient's best interest to receive life-sustaining treatment. Then at paragraph 39, Baroness Hale drew together her summary of the approach to determining best interest. Quote, "The most that can be said, therefore, is that in considering the best interests of this particular patient at this particular time, decision makers must look at his welfare in the widest sense, not just medical, but social and psychological. They must consider the nature of the medical treatment in question, what it involves, and its prospects of success. They must consider what the outcome of that treatment for the patient is likely to be. They must try and put themselves in the place of the individual patient and ask what his attitude to the treatment is or would be likely to be, and they must consult others who are looking after him or interested in his welfare, in particular for their view of what his attitude would be." Finally, in terms of wishes, at paragraph 45, Baroness Hale stressed that it was a subjective test, namely one focused on the individual, not an objective one understood by judges. She said this, quote, "Finally, insofar as Sir Alan Ward and Lady Justice Arden," they were the judges in the Court of Appeal in the James case, "were suggesting that the test of the patient's wishes and feelings was an objective one, what the reasonable patient would think, again I respectfully disagree. The purpose of the best interest test is to consider matters from the patient's point of view. That is not to say that his wishes must prevail, any more than those of a fully capable patient must prevail. We cannot always have what we want, nor will it always be possible to ascertain what an incapable patient's wishes are. Even if it is possible to determine what his views were in the past, they might well have changed in the light of the stresses and strains of his current predicament. In this case, the highest it could be put was, as counsel had agreed, that, quote, it was likely that Mr. James would want treatment up to the point where it became hopeless, end of quote. But insofar as it's possible to ascertain the patient's wishes and feelings, his beliefs and values, or the things which were important to him, it is those which should be taken into account, because they are a component in making the choice which is right for him as an individual human being, end of quote. Heading the proposed appeal. The parents' notice of appeal, filed on 18 July 2022, was supported by 6 proposed grounds of appeal, as follows. And then I propose to insert in the printed version the 6 grounds of appeal, which are well known to all those in this court this morning. The application for permission to appeal was listed to be heard by the full court, with appeal to follow on the afternoon of Thursday, 21 July. The court is most grateful to all those involved who enabled this very short time for case preparation to be met. In the event, oral argument continued the following morning, with judgment being given today, Monday, 25th July. Mr. Edward Devereux, who did not appear below, and who had been instructed after the proposed grounds of appeal and supporting skeleton argument had been filed, in presenting the parents' case at the oral hearing, chose to devote the entirety of his address to the court to a further ground of appeal, which, whilst not expressly pleaded as an amendment to the notice of appeal, can be found in the short headline note of submissions that he helpfully provided to the court. Quote, "The overall case of the parents is that Mr. Justice Hayden's decision was driven almost wholly by Archie's medical best interests and not by a careful, clear, understandable and comprehensive evaluation of Archie's best interests in the widest sense. In particular, it is argued, 1. The judge failed to give any real or proper weight to Archie's previously expressed wishes and his religious beliefs. 2. The judge failed to give any real or proper weight to Archie's family's wishes and views as to the continuation of life-sustaining treatment. 3. The judge failed to carry out a careful, clear and comprehensive evaluation of the benefits and burdens of the continuation of life-sustaining treatment. And 4. In making his best interest determination, the judge fell into error in concluding that Archie's life-sustaining treatment was 1. Burdensome, 2. Futile, 3. Compromising his dignity, depriving him of his autonomy, and wholly inimical to his welfare." End of quote. I shall refer to this new ground as the parent's primary ground. Although there was no express application to do so, I would give leave for the notice of appeal to be amended so as to add the primary ground as a further ground of appeal. Mr. Devereux informed the court that the parents still relied upon grounds 1 to 5 of the original grounds of appeal, together with the written submissions in support of them, in the skeleton argument drafted by Mr. Quintavalle, who, with Professor Robert George, is junior counsel for the parents. Ground 6, however, is no longer pursued. In order to concentrate fully upon the parents' primary ground, I propose to deal shortly with the application for permission to appeal on the 5 remaining grounds. Heading: Grounds 1 and 2, ECHR, CRC and CRPD. In grounds 1 and 2, it is asserted that the approach adopted by the judge, which involved disregarding or reinterpreting Archie's express wishes and desires, was wrong in law, because it was in breach of the rights established by a number of international conventions, that's ground 2, and that the judge was in error in failing to give reasons for his decision on each of those matters, ground 1. I am clear that permission to appeal should be refused on these 2 grounds, on the basis that they have no prospect of success. I have come to that conclusion for the following reasons. 1. European Convention on Human Rights, Article 2, relating to the right to life, places a positive obligation upon a state. The decision of the European Court of Human Rights in the case of Gard versus the UK, declaring the application in that case inadmissible, demonstrates that the court in Strasbourg will evaluate whether a domestic regulatory framework is in place that is compatible with the requirements of Article 2, whether account has been taken of the patient's previously expressed wishes and feelings and those of those close to him, as well as the opinions of medical personnel, and whether it is possible for parties to approach a domestic court in the event of dispute. Paragraph 80 of Gard. Different states have different approaches, and a margin of appreciation is to be afforded on this issue, albeit, as the case of Lambert against France demonstrated, the European Court of Human Rights reserves a power of review. The challenge under Article 2 in Gard, in the context of the regime in England and Wales in end-of-life cases, was declared to be manifestly ill-founded. Ground 2 in the present case is on the basis that, quote, the UK law, stressed, obliges the withdrawal of life-sustaining treatment where someone is in an irreversible state of unconsciousness with no prospect of recovery, unquote, and that emphasis is in the original skeleton. That basis has no foundation. The law in this jurisdiction does not oblige that outcome in every case. Each case is determined on its own facts, with the best interests of each separate individual being the sole determining factor. The second limb of this submission, that where a patient's known wishes are for the preservation of life, then, absent any breach of Article 3, Article 2 obliges life-sustaining treatment should be continued, is similarly without foundation, and none is offered in the skeleton argument. 2. The parent's case under ECHR Article 8 is that a patient has the right to choose the manner of their death. Reference is made to the case of Pretty against the UK and the case of Haas against Switzerland. And it's not therefore for the court to substitute its own view of best interests, which conflicts with those views. Again, this submission is misplaced. The cases in both Pretty and Haas concerned capacitous adults who had investigated the options facing them and who had come to a considered decision. Rather than reference to these two authorities, the appropriate European Court decision, human rights decision, is once again that of Gard, where at paragraphs 106 to 108 it was held that the child's best interests must be the primary consideration and that there is a broad international consensus that they indeed should be the paramount consideration. 3. The UN Convention on the Rights of the Child, whilst not incorporated into domestic law, is an instrument of influence upon the ECHR and is one to which regard should properly be had. Article 6 of that convention recognises a child's inherent right to life. The parent's case is that none of the exceptions permitted under Article 6 apply here, and the state, therefore, has a duty to preserve the right to life of a child to the maximum possible extent. No authority is put forward to suggest that a regime based upon a best interest determination is in breach of the CRC, and, as Counsel for the Hospital Trust observe, the relevant authority to which regard must be had on this point is again the case of Gard, where, as I've indicated, the European Court of Human Rights expressly endorsed the domestic regime based upon paramount consideration being afforded to best interests. 4. Article 10 of the UN Convention on the Rights of Persons of Disability affirms the right to life of every human being and asserts a right for disabled people to ensure its effective enjoyment on an equal basis to others. By Article 12, disabled people should have equal status with others under the law. The Parents' Council submission is that, quote, a decision to remove life-sustaining treatment from someone who previously had capacity can only be made on the basis of the person's will and preferences, and failing this, then according to the best interpretation of will and preferences, end of quote. These submissions, in the context of a person who is so disabled that they have no freestanding capacity for life without artificial and intensive medical intervention, appear to stretch the parameters of this convention beyond its intended boundaries. But be that as it may, it is clear from paragraphs 39 and 45 of Aintree, to which I've already made reference, and elsewhere, that the approach in domestic law does afford due respect to the wishes and feelings in a manner that would be compatible with the principles of CRPD Articles 10 and 12. 5. It is correct that the judge did not give attention in his judgment to these 4 convention-based submissions. On the basis, as I have held, that they are without foundation, he was right not to do so, and there is therefore no prospect of success on appeal on grounds 1 and 2. Ground 3, erroneous findings of fact. The judge held that, quote, there can be no hope at all of recovery, end of quote, paragraph 45. I've already referred to the patient's solicitor's letter of 17 July, in which the medical opinion as to there being no prospect of recovery was accepted. The Parents' Council's skeleton argument nevertheless presses a challenge to the judge's finding on recovery by relying on the evidence of one of the medical experts who, it is said, had referred to there being a chance of recovery in the order of, quote, 1%, unquote. Counsel for the Hospital Trust point out that the witness was giving an illustration of the prospects of recovery drawn from data relating to adults with a similar pattern of injuries. Secondly, the evidence of that witness was that the degree of, quote, recovery, unquote, described was extremely limited and was to move a patient, quote, from a comatose state into some sort of persistent vegetative or minimally conscious state, end of quote. The judge's finding on the absence of any prospect of recovery was based upon a comprehensive review of all of the medical evidence. The determination of questions of fact are preeminently matters for a trial judge, and the Court of Appeal will only interfere when there are clear grounds for regarding any particular finding as unsafe. reference to the short evidence of this one witness could not possibly provide the foundation for such a challenge. In any event, even if a patient were to move slightly up the coma scale, that would, sadly, have no impact upon the accepted probability in this case that Archie will die in any event during the course of the next few weeks. The second factual challenge is that the judge was in error in relying upon the evidence of an independent expert, Dr. Playfaugh, who conducted an informal brainstem evaluation on the occasion that he visited Archie. Formal pre-brainstem testing was subsequently undertaken and revealed that Archie's peripheral nervous system was unable to respond to stimulation, which in turn indicated that full brainstem testing could not be undertaken. As paragraphs 16 and 7 of the judgment demonstrate, Dr. Playfaugh's evidence was based upon a full examination of Archie and his medical history. The informal brainstem evaluation, which is not mentioned by the judge, was but one aspect of a full and comprehensive assessment, which, as the judge states, included finding Archie to be, quote, entirely unresponsive with absent pupillary, cough, gag, corneal, and ocular vestibular reflexes, and, quote, no respiratory effort during a 2-minute informal apnea test, unquote. The third factual challenge relating to the judge's finding that Archie could not breathe as a result of damage to his brain is based upon a potential alternative mechanism described in the skeleton argument as, quote, in fact, the secondary spinal cord damage, which was discovered as a result of the MRI of 31st May 2022, was likely to make breathing impossible and thus invalidate the apnea test, end of quote. Here, the crucial finding is not concerned with the mechanism, as suggested in the skeleton argument, but with the fact that Archie is unable to sustain breathing independently of the ventilator. A reading of the judgment as a whole does not indicate that the judge regarded this as being solely caused by brain damage. However, as the judge was not concerned, in contrast to Mrs. Justice Arbuthnot at the earlier hearing, to diagnose brainstem death, the point does not have any impact on the judge's overall findings and therefore has no relevance in terms of any potential appeal. Ground 4, burdensome, futile, and compromised dignity. Ground 4 asserts that in making his best interest determination, the judge erred in fact and in law in holding that Archie's treatment was, quote, burdensome, unquote, quote, futile, unquote, and, quote, compromised his dignity, deprives him of his autonomy, and leaves and becomes wholly inimical to his welfare, unquote. In relation to burden, the Parents' Council's skeleton seeks to limit the meaning of burden in this context to that described in the Royal College of Paediatrics and Child Health Guidance, by restricting it only to any consequence of treatment that causes pain or distress. The judge accepted the medical evidence that Archie was likely to be beyond experiencing pain. The hospital trust submit that the judge's findings that the multiple elements of treatment and its impact on Archie's body are evidence of burden was a finding that the judge was entitled to make. At paragraph 46, the judge held that, quote, treatment is futile, unquote. The Parents' Council accept that it is not the purpose of mechanical ventilation to bring about recovery from brain injury, but they submit that it doesn't mean that the treatment is futile in circumstances where that is the very means of keeping the child alive. Reference is made to paragraph 40 of the judgment of Baroness Hale in Aintree, where futility was considered in the context of treatment that is ineffective or of no benefit to the patient. Paragraph 40 of Aintree is, in my view, to be read as a whole, where, firstly, the focus is on whether, as the Court of Appeal in Aintree had held, treatment must have a real prospect of curing, or at least palliating, the underlying condition. And secondly, the court was looking at alternative treatments, which might allow Mr. James to resume a quality of life that he would consider worthwhile. On that basis, if, as I read his words, Mr. Justice Hayden was indicating that the current treatment could not achieve any improvement in Archie's condition, his words were in keeping with those of Baroness Hale, and are not therefore open to criticism. The parent's case on dignity is, firstly, that some element of indignity is always present in cases such as this, and is therefore to be accepted. Secondly, it is submitted that any such indignity cannot outweigh the sanctity of life principle and the right to life that is protected by international conventions. With regard to autonomy, it's submitted that it is the original injury and not the treatment that has deprived Archie of his autonomy, and that secondly, effect can still be afforded to Archie's autonomy by allowing his wishes and feelings to prevail. Standing back against the judge's findings on the medical evidence, in circumstances where Archie is unable to experience anything that occurs to him or around him, either painful or pleasurable, the judge was entitled to hold, as he did, that the medical regime, quote, serves only to protract his death, whilst being able to prolong his life, end of quote. In those circumstances, his findings as to dignity and autonomy, futility and burden were fully open to him and entirely justified. Specifically, the judge was entitled to find that the treatment carried a burden for Archie, even though he has no capacity to experience pain and no conscious awareness. See Parfitt versus Guy's and Thomas Children's Hospital Trust and Knight, 2021, EWCA Civil 362, paragraphs 57 to 62. Ground 5, the presumption in favour of prolonging life. By ground 5, there is a direct challenge to the judge's finding that the current treatment serves, quote, only to protract his death whilst being unable to prolong his life, unquote. The Parents' Council submit that, quote, this can be interpreted in only two ways. The first, that, as a matter of fact, the life-sustaining treatment is unable to prolong Archie's life. The second, that any life that is being prolonged does not qualify as a life of sufficient quality to be protected by the sanctity of life presumption or by Article 2 of the ECHR. End of quote. Both possible interpretations they submit are not tenable and are wrong. It is plain that Mr. Justice Hayden had full regard to the strong presumption in favour of prolonging life. He makes express reference to ECHR Article 2 and quotes directly from Burke against the UK, referring to, quote, the presumption of domestic law being strongly in favour of prolonging life where possible, unquote. That's the judgment, paragraph 39. He later quotes Lady Black in the case of NHS Trust against Y, who said, quote, no life is to be relinquished easily, end of quote. In response to this ground, the Hospital Trusts submit that the presumption regarding the preservation of life must, and on the authorities does, have to yield to stronger, counter-prevailing best interest factors in those cases where permission is given to withdraw life-sustaining treatment. The Trust, correctly in my view, interpret the judge's reference to protracting Archie's death as referring to the medical findings, which are that, should treatment continue, all that will occur is a further deterioration in Archie's condition, with resulting organ and or heart failure leading to death in some weeks, with no prospect of achieving any improvement in his condition. On that interpretation, the judge's analysis, whilst being bleak in the extreme, is fully justified and is in accordance with the established principles. Conclusion on pleaded grounds of appeal. On the basis of that analysis, and on the basis that ground 6 is not being pursued, I would refuse permission to appeal on the pleaded grounds of appeal numbered 1 to 5, on the basis that both individually and taken together they do not have a reasonable prospect of success. Heading: the parent's primary ground. I turn finally to what I have described as the parent's primary ground, which was advanced orally and for the first time during the hearing. I have already set out Mr. Devereux's formulation of the ground. In essence, his submission is that, whilst the judge may have mentioned all of the relevant factors in the body of his judgment, nowhere does he demonstrate that he conducted the required balancing exercise or indicate what weight he attributed to each element before reaching his final determination on best interests. Put another way, if the medical factors might be listed as A to F and the non-medical factors at G onwards, with the best interests conclusion being at Z, the judge, submits Mr. Devereux, has simply gone from A to F and then to Z, without taking account of any non-medical factor. Whilst Mr. Devereux was at pains to avoid insistence upon the judge expressly using a balance sheet of pros and cons regarding Archie's future treatment, he submitted that there must, in any judgment of this nature, be a section which is the, quote, engine, unquote, of the judicial analysis, where the judge's working out of the competing factors is explained. In doing so, he relied upon a recent judgment of my Lord Justice Peter Jackson, in the case of Re B, a child, Adequacy of Reasons, 2022 EWCA Civil 407, in which helpful guidance was given on the content and structure of judgments. At paragraph 59, it is said that a good judgment should have within it at some point, and as concisely as possible, a number of elements, including, quote, 7, evaluate the evidence as a whole, making it clear why more or less weight is to be given to key features relied upon by the parties, and 8, give the court's decision, explaining why one outcome has been selected in preference to other possible outcomes, end of quote. Mr. Devereux submits that, whilst the judge refers correctly to the legal context, in particular the Aintree case, he fails to engage with the exercise that is required by that authority. From the parent's perspective, the all-important factors in this decision are Archie's stated wishes and religious belief. Mr. Devereux listed the 7 factors that he submits were before the judge and which should have been taken into account in the balance in favour of maintaining the current treatment regime. They are 1, the presumption in favour of prolonging life, 2, Archie's wishes and feelings, 3, Archie's religious beliefs and values, 4, the family's wishes and beliefs, 5, the fact that Archie does not experience pain, 6, the benefit of allowing Archie to die at a random time and in a natural way, and 7, the prospect of there being some limited recovery. Where, at paragraph 25 of the judgment, the judge expressly stated that, quote, determining where Archie's best interests lie is not solely a medical issue, end of quote, Mr. Devereux accepts that that was a correct self-direction, but he submits it is one that the judge then failed to follow. At paragraph 30, the judge stated, quote, I am considering Archie's best interests in the context of a young man who believed in God and whose family believe in God, end of quote. At paragraph 32, the judge stated, my concern is with Archie, but what he might have wanted is integral to my evaluation of his best interests, end of quote. Again, Mr. Devereux submits that although the judge made these statements, he did not carry these factors forward into his ultimate evaluation of best interests. Mr. Devereux took the court through the structure of the judge's judgment, in which he gives an account of the medical evidence, the evidence of the family, the legal context, before turning in the final 5 paragraphs to be setting out his conclusions. In view of the challenge that is now made to the judge's analysis, it's necessary to set out paragraphs 42 to 47 in full, and the typed version will have those paragraphs included. Mr. Devereux makes a number of specific points about these paragraphs. A. Whilst the choice before the judge was between option 1 and option 2, as they've been characterised during the appeal hearing, the judge did not look at the issues before him in that way. B. Paragraphs 42 to 44 are not part of the judge's conclusion. They are simply a recital of part of the Guardian's report. C. The conclusion is at paragraphs 45 and 46, and they contain no mention of wishes and feelings. D. In holding that the family had been, quote, ambushed, unquote, by their emotions, the judge went beyond findings that were open to him on the evidence. In response to the parents' primary ground, Mr. Gavin Miller, QC, who did not appear below, for the Hospital Trust, submitted that the judgment should be read as a whole. He, too, took the court through the structure of the judgment in order to demonstrate that the judge did have regard to all of the relevant factors. Mr. Miller drew attention to paragraphs 23 and 24, where the judge describes the likely progression if Archie were to continue to receive life-sustaining treatment, with the conclusion, in the judge's words, being that, quote, eventually Archie's organs will fail and ultimately his heart will stop. How, when, and in what circumstances, it is impossible to predict, end of quote. The judge then goes on to say, quote, what I have set out above is a bleak prospect, but in invidious circumstances, it is one that his parents are driven to prefer. The alternative is that advanced by those caring for Archie and by his guardian, end of quote. Mr. Miller submits that in those 2 paragraphs, the judge accurately sets out the choice that was facing the court in very clear and certain terms, with the 2 options that required consideration being squarely identified. At paragraph 33, the judge stated that he is, quote, required to confront the compelling medical reality that Archie no longer has the agency to fight, end of quote. And Mr. Miller submits that the judge must have carried forward that finding of, quote, compelling medical reality, unquote, to his final determination. Mr. Miller disputed Mr. Devereux's assertion that paragraphs 42 to 44, which include extensive quotations from the Guardian's report, do not form part of the judge's reasoning. Given their place in the structure of the judgment, and the obvious endorsement that the judge attributes to the Guardian's analysis, these passages are, submits Mr. Miller, to be taken as part of the judge's own evaluation of the relevant factors. In response to Mr. Devereux's criticism that the judge has failed to identify what weight he attributed to any particular element in his assessment, Mr. Miller pointed to the quality of the language used by the judge in describing the medical factors of paragraph 46, quote, on, underlined, most compelling evidence, and then later, I am driven, underlined, to conclude that that is not in Archie's best interests for ventilation to continue. And that was Mr. Miller's emphasis orally. Whilst it is not presented in the form of a balance sheet, Mr. Miller submitted that all of the elements that the judge was required to consider are included within the judgment and must have been taken fully into account by the judge before reaching this determination. Mr. Miller submitted that it is obvious which factors fall in favour of option 1 or option 2, and there was no need for the judge to itemise them in that way. Finally, Mr. Miller observed that if there was any merit in the parents' new ground, it was merely to identify a failure of presentation by the judge in not drawing all the factors together in one's final summary. Such a failure could not change the outcome. For the children's guardian, Miss Claire Watson, Queen's Counsel, who appeared below, submitted that the judge carried out a careful and sensitive best interest analysis that was entirely in accordance with the requirements of the law before reaching a conclusion which was fully open to him. She, too, urged the court to look at the judgment as a whole and to consider paragraphs 23 to 27 and 32 to 34 as part of the judge's, quote, workings, unquote, in addition to the later passages. Miss Watson told the court that, as the medical evidence was taken as read, more time was spent during the hearing before Mr. Justice Hayden in focusing on Archie as an individual. Miss Watson drew attention to Section 31A of the Children Act 1989, which requires the court to have regard to the ascertainable wishes and feelings of a child, quote, considered in the light of his age and understanding, unquote. Although the judge might have taken account of the fact that Archie was 11 years old at the time that he spoke to his brother about end-of-life treatment, and the judge would have been entitled to reduce to a degree the weight to be afforded to his wishes and feelings when compared to those of an adult, there is no sign that the judge did so in this case. Heading Parents' Primary Ground, Discussion and Conclusion. The central criticism made of the judge's judgment by Mr. Devereux is that set out at subparagraph 3 of the new ground, namely that, quote, the judge failed to carry out a careful, clear and comprehensive evaluation of the benefits and burdens of the continuation of life-sustaining treatment, unquote. Subparagraphs 1, 2 and 4 are illustrative of that central point. It is further argued that the judge's stated reasoning does not allow the reader to see how he has worked through the issues in the case so as to reach his conclusion. It is important to stress that the proposed appeal does not engage with any point of law. The criticism that is made relates entirely to the manner in which the judge conducted his assessment. it being accepted that he gave himself a correct direction on the law. In the absence of any proposed ground of appeal to the contrary, it seems that it is also accepted that the judge's decision was open to him on the evidence. Mr. Devereux does not submit that the outcome chosen by the judge is, quote, wrong, unquote, in the sense that that word is used in describing the test on appeal. If the appeal is successful, the parents seek a further rehearing before a different judge. The parents' primary ground, as developed by Mr. Devereux during the course of his skilful oral submissions, is plainly not without some foundation. It would undoubtedly have been better for the judge to have been more explicit in setting out his final conclusions. But there is a danger that the metaphorical microscope deployed by an appellate court can become over-focused on particular words, or what is not said in one sentence or another, so that sight may be lost of the judgment as a whole. If, as Mr. Miller submits, any failure is only one of presentation, the court must be careful not to be drawn into allowing an appeal and possibly ordering a rehearing where, in reality, there has been no substantive error by the judge. During the hearing, my Lord Justice Peter Jackson, observed that all that is missing is one paragraph, and because of what the judge does say, the missing paragraph would write itself, as its contents are made clear by what is said elsewhere. If that is so, then this new ground of appeal would lack any substance and must fall away. Putting the appellate microscope to one side and looking at the judgment as a whole, the first question is whether the judge did consider each of the relevant factors. If so, the second question is whether it is possible to understand what weight he attached to each factor before coming to the ultimate best interest determination. Mr. Devereux listed 7 points which were in favour of the parent's case and which he submitted had not been brought into the ultimate evaluation exercised by the judge. Save for the final one, each of these points does, however, appear in the judgment. 1. Presumption in favour of prolonging life, paragraph 39. 2. Archie's wishes and feelings, paragraphs 31 and 42. 3. Archie's religious beliefs and values, paragraph 30. 4. The family's wishes and beliefs, paragraphs 32 and 42. 5. The fact that Archie doesn't experience pain, paragraph 23. 6. The benefit of allowing Archie to die at a random time and in a natural way, paragraphs 31 and 32, which identified this as being in line with both Archie's and his mother's wishes. The 7th factor, namely the prospect of there being some limited recovery, was plainly not accepted by the judge, and I have already dealt with this point at an earlier stage. At paragraph 32, the judge said, quote, "My concern is with Archie, but what he might have wanted is integral to my evaluation of best interests," unquote, and at paragraph 34, quote, "When determining his best interests, I must have regard to the range of Archie's needs and wishes," unquote. After further narrative describing the requirement for consideration of dignity, in addition to needs and wishes, the judge says, paragraph 35, quote, "It is for these reasons that I have taken care to investigate Archie's life, and I am grateful to his parents for opening it up to me. I also regard it as a privilege. I am grateful to Archie's guardian, who has provided a detailed and illuminating report in circumstances which would have been difficult for all involved." Close quote. As Miss Watson confirmed, investigating who Archie was and what his wishes and feelings might be was the central focus of the hearing. It was, in essence, what the case was about, in circumstances where the medical evidence was taken as read and was all one way. In those circumstances, it becomes very difficult for a potential appellant to argue that a judge who has on 3 occasions expressly said that he must consider wishes and feelings, and who sets out and accepts the evidence of religious belief and a stated desire not to have life support turned off, in some manner then ignores those factors when he comes to his decision some 6 paragraphs later in the judgment. I do not accept that the judge's analysis is to be limited to paragraphs 45 and 46. It plainly must include paragraphs 42 to 44, in which important quotations from the Guardian's report are set out with obvious approval. In paragraph 42, the focus is on Archie's religious beliefs and his mother's view that Archie would wish for more time and would not want to leave her. Against that background, it is not possible to hold that the judge failed to have regard to these important factors in his final analysis. Like the Guardian, he plainly treated the views of the family about Archie's best interests with proper respect, and when declining to endorse them, he expressed the most profound regret. But he did not, and was not obliged to, give decisive weight to those matters in the face of the overwhelming medical evidence. In terms of the attribution of weight, by his clear endorsement of the Guardian's analysis, quoted at paragraph 43, quote, "She continued, if I may say so, with great sensitivity," unquote, the judge adopted the Guardian's words as his own. Within that paragraph, Archie's wishes are clearly acknowledged, as is the, quote, "undisputed and overwhelming," close quote, prognosis that, quote, "he will not get better," close quote. The text then proceeds by recording great thought being given to Archie's wishes and religious beliefs, but these are balanced by the observation that, quote, "For the reasons highlighted above, I do not consider that he could have in any way foreseen the circumstances where they are being relied upon now. Given what I have been told about him, I would expect him to find the restrictions of his current situation difficult to bear," close quote. Well, that approach would appear to be on all fours with paragraph 45 of the decision in Aintree. Whilst it might be said that the judge could have been more explicit by indicating expressly that he agreed with and adopted the Guardian's analysis, it is plain that that is exactly what he was doing. I accept the submissions made by Mr. Miller and Miss Watson. In particular, whilst he did not label them as we have done, the judge does at paragraphs 23 and 24 precisely identify the choice that was to be made. The exercise that was the focus of the oral hearing before this court has been a valuable one, and I am grateful to Mr. Devereux for embarking upon it, as it has caused me to evaluate the judgment both from the perspective of precise consideration of individual sentences or words, but also as a whole. Despite initially identifying some potential validity in the points made on behalf of the parents, arising from the fact that it is true that the judge did not describe his analysis in one or two explicit or structured paragraphs, the detailed reading of the judgment that I have now undertaken, supported by the helpful submissions of Mr. Miller and Miss Watson, has removed any doubt. It is clear to me that the judge discharged the important responsibility laid upon him correctly and in accordance with the law. I recognise that the outcome was not one that Archie's family had hoped for, but the judgment read as a whole makes it apparent to all why the judge reached the conclusion that he did. Whilst it is most sadly correct that it was the medical evidence that ultimately drove the outcome of the judge's best interest determination, he had clearly taken full account of the countervailing factors. Those factors, and in particular Archie's wishes and feelings and religious beliefs, were insufficient to avoid a finding that the continuation of life-supporting treatment was no longer in the best interests of this moribund child, who is weeks away from a death which will otherwise occur from a further deterioration and then a failure of his organs, followed by the failure of his heart. Consent can only be given to medical treatment where it is in the patient's best interests, and the consequence of the judge's assessment is that continued life-sustaining treatment for Archie will not be lawful, even for a period of days or weeks. Permission to appeal can only be granted on the parent's new ground of appeal if there is a real prospect of it being shown that the judge's decision was unjust because of a serious procedural irregularity arising from the manner in which he approached the decision and expressed his reasoning. After a detailed examination, I do not accept that there is any prospect of the decision being shown to be wrong or unjust, whether for procedural reasons or otherwise. The new ground of appeal relates only to matters of form and raises no matter of true substance. In the circumstances, I am satisfied that an appeal on this ground does not have a real prospect of success, and that there is no other compelling reason for granting permission to appeal. In this truly tragic case, Archie's best interests have rightly and repeatedly been given the most anxious attention, and the judge has made a conscientious decision that this court would not disturb. Permission to appeal on this final ground must, if my lady and my lord agree, also be refused.
I agree.
I also agree.
So, unless there are any other matters, Mr. Devereux, that concludes our deliberation.
Thank you, my lords and my ladies. The question of the position of the current declarations arises, and I'm instructed to seek a limited stay to permit the parents the ability to apply to the European Court under the Rule 39.
The European Court?
European Court of Human Rights, under the Rule 39 process, which allows them to request interim remedies. There is, in addition, of course, an anticipated application concerning the new evidence that they have submitted to the court and will seek to submit before Mr. Justice Hayden in due course. But in relation to the application for a stay, what I seek is a stay for 7 days to allow a request to be made to the European Court of Human Rights under the Rule 39 procedure within the rules of court. In support of that, I would like to take the court to 2 judgments, if I may.
Yes.
The first is the case of Mamatkalov, Askarov and Turkey. And I don't know whether your lordships and your ladyship still have the authorities bundle.
I haven't. I've got the bundle from the first appeal that I was using for Aintree, but nothing else.
Can I read out
Yes.
the section?
Could
Which
you just
tab
give
is
us
it
the
at?
Tab, please.
Yes, I'm so sorry. It's tab 27 and it's page 660 within that, well, within the authorities bundle it starts at, but within the judgment itself, it's paragraph 102. And what that case says at sentence 3 is this: it is of the utmost importance for the effective operation of the system of individual application instituted under Article 34 that applicants or potential applicants, and I interpose the fact that the parents here would be the potential applicants, should be able to communicate freely with the court without being subjected to any form of pressure from the authorities, that's to say the court here, to withdraw or modify their complaints. As the court has noted in previous decisions, pressure includes not only direct coercion and flagrant acts of intimidation against actual potential applicants, members of their family or legal representatives, but also other improper indirect acts or context designed to dissuade or discourage applicants from pursuing a convention remedy. For present purposes, the court concludes that the obligation set out in Article 34 requires the contracting states to refrain not only from exerting pressure on applicants, but also from any act or omission which, by destroying or removing the subject matter of an application, would make it pointless or otherwise prevent the court from considering it under its normal procedure.
Yes.
That's the passage that I seek to rely on. The second authority I seek to rely on is the decision of the Supreme Court following its refusal of permission to appeal in the case of Charlie Gard. And within the authorities bundle at tab 13 at page 262, this court will find that consequent decision. That decision concerned, of course, the then application anticipated by the parents in that case presented to the Supreme Court that they themselves would apply under the Rule 39 procedure to the European Court of Human Rights. And within that judgment, at paragraphs 18 to 20, the Supreme Court indicate that notwithstanding that any stay might be seen as contrary to Charlie's best interests, they having refused permission to appeal, within a procedural context, it might not be the case that Charlie's best interests dictated the outcome. And the Supreme Court, in those circumstances, directed that the judge's declarations, Mr. Justice Francis's declarations, be further stayed for a period of 3 weeks.
Yes.
In essence, therefore, what we say is we seek a short period of time to be able to seek relief, which would be obliterated or denied to us if this court were not to make a
So
stay.
I clearly understand the point. It's possible, isn't it, to communicate with the court in Strasbourg almost immediately and in a much shorter period than 7 days.
Well, what the Guard case shows is that certainly initial communications can take place pretty quickly. But
I mean, a way of moving, I'm certainly sympathetic to there being a short stay to allow you to approach the court in Strasbourg should you wish. My lady and my lord may or may not agree with me. But normally in that context, or indeed any other context with an appeal from a lower court to a higher court, some control is kept of the timetable for
I anticipate
stays by initially only giving a really very short period of time, while stock is then taken as to more precision as to how much time is needed.
Yes.
By the roundabout way of saying, it would be helpful to know how long Strasbourg say they would need to engage with this.
yes, and I can't answer that question,
No,
but I accept the general principle.
In my head, just thinking that through, and clearly you may have submissions, others may, and my lady, my lord might, a period of 48 hours would give us more, would there be more known knowns
Yes.
about the situation than we are able to have at this stage on
Yes.
Monday afternoon.
And I can see the force in that.
Right, so that's your application to us,
That's my
which is
application.
of a short stay,
Yes,
time to be determined, to allow you to do that.
yes.
What happens in relation to any other application back to the High Court is clearly a matter for the parties and for the High Court. That's not a matter for us
Yes,
to
I understand.
take account of. Thank you. Mr. Miller, do you have any submissions to make about that?
Just instructions, which I hope assist as to what the hospital's position would be, absent any consideration of a stay in the ordinary course. You'll recall the order under appeal contained in the recital a record of what we had informed Mr. Justice Hayden was the intended timescale for the withdrawal of treatment. That, of course, is now passed because of this appeal and the orders made on this appeal. So I don't know whether the court would wish us.
Well, I think
to give an
just
indication.
also thinking about events today, there's a need also for clarity about Mr. Battersby's position and any planning. So I wonder whether it's more profitable to allow you to take some instructions and consider your position on that, and Ms. Watson as well, rather than press you to give me a response now.
Yes.
Um,
I mean, I have taken instructions, but they do recognise the difficulty of Mr. Battersby's
Yes.
position. So the instructions, in effect, there would have to be some flexibility.
Yes. Yes.
Uh,
So
extended time.
if a stay was to be measured so far as procedurally, this court is concerned in terms of 48 hours, that's unlikely to compromise any other plans you would have been developing in any event.
Not substantially.
No. No, Ms Watson.
My Lord, we would simply endorse the approach that the court is advocating, that is to keep a control over the timetable and allow for a degree of flexibility.
Right.
And the 48 hours proposed is certainly going to be in keeping with that.
Yes, and if it helps more, I mean, the Strasbourg court can make an interim order very quickly, and you recall in the recent Rwanda judicial.
Yes, no,
there was an overnight phone call.
they have a ready channel of communication
Yes.
with this court, as they no doubt do with every other country, and they're adept at spotting the cases such as
in
this
very short
need
order.
agility. So, Mr. Devereux, on the basis that further applications can be made to extend the time, but on the basis that the expectation is that if you are going to go make an application to Strasbourg, you move quickly. We propose to grant a stay until 2 p.m. on Wednesday, which is effectively 48 hours.
Thank you very much.
I will ask the office here to communicate with the office at the court in Strasbourg to alert them to the fact that this may be coming.
Thank you.
Are there any other matters that we can usefully deal
Can
with?
I-
I think
can I just-
if there are, they can follow and be dealt with on paper. Yeah. And just while that's happening, we rely on council to draw up an order. As I indicated earlier, we'll endeavour to get a fair copy of the judgment available to everyone later on this afternoon.
And nothing more from me. Thank you very much.
Thank you. We'll rise.